What do you find are some common misconceptions people have when it comes to bankruptcy? Attorney Michael McLaughlin explains.
One of the main misconceptions that individuals have about bankruptcy is that their credit and their life will be ruined forever if they choose to file a bankruptcy case. In reality, the opposite is very often true. Achieving a discharge and debt relief in bankruptcy will help them solve difficult life problems and extricate themselves from the vicious cycle of enormous debt and credit card interest. A person's credit score will decrease substantially in the short term, but will later increase upon post-bankruptcy improved payment of revolving debts to the point that they will eventually be able to qualify for auto loans and a mortgage. Another misconception people have is that their employer will become aware of their bankruptcy case and fire them. However, there's a federal statute which protects individuals from being discriminated against simply for their action of filing bankruptcy. A third misconception is that a person will have to surrender all of their personal property to a trustee in bankruptcy, which is not true. The exemptions, which are defined amounts of assets people can keep in bankruptcy, are generally fairly reasonable. For example, the most significant exemption of $25,000 of equity in real estate for one person and $50,000 for a joint filing between a husband and wife is one major item that can be kept by debtors.
The law offices of Michael McLaughlin LLC is one of New Jersey's most experienced and respected in the field of bankruptcy representation. The firm acts for both debtors and creditors.